All right, so welcome to our March 2022 recording for our Lunch and Learn. We are learning about partnering with parents. So I'm going to turn it over to Mark Hudson, who is a deputy child attorney. He's going to introduce himself and then he's going to do our training. Thanks, Mark.
Thanks, Lauren. Good morning or afternoon, I guess. I'm Mark Hudson. I'm a deputy child advocate with the Office of the Child Advocate. I've been in this role for about 6 years, and prior to that, I had been representing parents in these cases for about 6 years. So I was supposed to be joined today by Stephanie Reed, who is a parent attorney in Sussex County. However, she is stuck in court. So if you've not learned about the unpredictability of court yet, this can be your first lesson in that topic. So she's maybe going to be able to join us later, but maybe not. I hope she is, but we'll have to wait and see. So I'm going to attempt to share my screen now, and I'll get started with the program. I know Lauren said to hold questions till the end. It's just two folks on here, so if you guys have questions as we go, feel free to jump in and ask questions. So let me try to share my screen, and hopefully I can not mess this up too much. All right, do people see my screen?
Yes, sir, you're good to go.
Okay, great. So the first page doesn't have a whole lot going on. So like I said, Mark Hudson, I am Mark Hudson. Stephanie Reed was supposed to be here, who is unfortunately unavailable. So just starting out with some basics in terms of reunification being the primary reason why kids exit care in Delaware so far. So this is kind of just to highlight the importance of working with parents. Generally, we view reunification with the parents to be the most favorable outcome in these cases, broadly speaking. And currently, in the most recent data we have is that 36% of the exits from foster care were going to parents in some sort of reunification. And you can see that coming in second was guardianship, aging out, TPR adoption, and lastly, permanent guardianship. So, there are exceptions for sure, but generally we like to get kids home with parents when possible. So it's important that we work with them and be able to assist them while still representing the interests of the child in that regard. This is just some of the stuff that we'll be covering here today about respectfulness, procedure and structure, supporting permanency, and then hopefully we'll have some questions that I'm able to answer. Starting with respectfulness. So we want to remember to treat parents with dignity and respect, of course, at the beginning. They might come from situations and backgrounds that are a little bit different from ours, and they might be in positions that are challenging for them, but we always want to remember to treat them with respect and dignity as well. And this will go a long way, not only in making the parents feel better and not disrespecting the parents, obviously, but it will also help with your establishing a relationship with the parents. Because if you disrespect the parents coming out of the gate and they get a bad impression, then it's probably going to be difficult to work with parents going forward. They probably aren't going to be very excited to talk to you or view you kind of as the bad guy, when that's not our role at all in terms of these proceedings. So we want to be sure to use respectful word choices. Parents in these cases don't need the CASAs or anybody else to be parents to them. So we're not going to necessarily, it's better not to be condescending towards them, to blame them for what's happened with the child, that sort of thing. So we want to just kind of keep things on good terms with the parents as much as possible, because that will facilitate things further in we go. And I know that a lot of training these days is focused on the trauma-informed approach with children, because a lot of these children, if not all of them, in foster care have experienced trauma, and there are certain effects that has on the brain and certain ways that are better with dealing with people who have experienced trauma than others. And we should all be mindful that parents in these cases have most likely come from a background that involved considerable trauma themselves. So just like we treat children in these cases with a trauma-informed approach, we should be treating the parents of that and mindful of that as well with them. In terms of, so we have lead-off topics. One of the things that we should try to avoid doing is leading off with asking for parents for releases for information. Okay, so like if the parents are just meeting you, the first things out of your mouth are, hey, I'm so and so, the CASA for these children, can you please sign this consent so that I can get your mental health records or your drug treatment records, that sort of thing. It's not a very great way to lead off. In terms of getting consents and that sort of thing, those are very important. We need those consents so that we can follow the parents independently and track what they're doing. The best way to do it, in my opinion, is to ask, if the attorney hasn't already brought it up, speak with your attorney about it. And then the attorney can speak to the parent's attorney, and the parent's attorney can get the parent to sign that consent when it's an appropriate time and in a respectful manner. It sometimes comes off better that way. We want parents' attorneys to know about the consents anyway, in case they have issues with them, they can talk it over with the parents. So in terms of like leading off, we probably want to avoid leading off with, here's 2 consents or 3 consents. Can you please sign these? We're having conversations with the parents and treating them like people. We also don't want to be interrogating parents. There are certainly going to be questions that we have for the parents about the situation that led the child into care, about their present living situation, their present working situation, mental health, everything. We want to know lots about them, but we don't want to do that in an interrogating way. It should be more conversational. Again, we want to try to preserve the relationship, have the parents view you as the CASAs as someone whom they can speak with, who they're not viewing as adversaries necessarily, and can just facilitate that relationship to make things easier down the road. Some of the things we want to avoid when we're thinking about parents in these situations is comparing them with the kids' current situations. So in other words, this isn't, when we're working with parents, it's not a comparison of this is what life was like with mom and dad, and this is what life is like in the foster home. The foster home is so much better. So we should, that if the parents can't provide a home like the foster home's providing, we should be in support of, termination of parental rights or whatever, not reunifying the parents with their child. So we want to avoid that. We're not trying to have perfect parents in these cases. We're just trying to have adequate parents. And that can look a lot different for different parents. And it most of the time does not rise to the level of the care that children are receiving in foster care. I mean, quite frankly, the foster parents are probably going to end up having nicer homes a lot of times. They're going to be more educated and more in tune with children's needs and development in general. And we're not trying to make parents as good as foster parents. We're just trying to help them become adequate parents. So we have to keep in mind that we're not comparing parents' homes with foster homes. And sometimes reunification might look different than what we all hope for. So we have to manage our expectations in the reunification process. So sometimes a successful reunification might be to a home in a very bad neighborhood. I've seen that happen before where we've had appropriate homes, the home's physically appropriate, and the parents have completed their case plan to whatever degree needed, but the home is in a very bad neighborhood and there's concerns about that. And it's always good to note these concerns when talking with your coordinator, with the attorney, but we have to understand that that's not necessarily going to prevent the child from returning home because the home's in a bad neighborhood, just as an example. We have to be prepared that sometimes parents might not talk to their children the way that we would talk to our children, or that the foster parents might talk to them. Sometimes, there's going to be some disparity probably in education between the parents and the other players in this process. So we have to be respectful of that. Sometimes a parent might try to motivate a teenager to do well in school by saying that they're going to, kick them in the butt or something if they don't get their act together in school. And generally that's not an actual physical threat. That's just the way that they're trying to motivate them. So we have to just be mindful that it's not always going to be perfect when these kids return home to parents, and parents aren't expected to be perfect. Poverty and neglect are 2 different things. So there's actually case law in Delaware that says you cannot terminate parental rights just based entirely on poverty. So poverty is not unfitness. So if there is a case where we have parents where poverty is the primary issue. They just can't maintain a house because they don't have employment, or it's not related to substance abuse, mental health, that sort of thing, then we really need to brainstorm with the Division of Family Services, with a parent's attorney, about things that we can do to help the parents overcome that poverty. Are there supports that we can put in place, because there is a difference between poverty, dependency, and neglect. So, and another thing to keep in mind in the perspective of all of this is that this is a process that doesn't happen overnight. The parents are generally afforded a year to reunify with their kids. Sometimes it takes that whole year, sometimes it's shorter, sometimes it's longer. What we're looking at in a lot of these cases is a pretty significant lifestyle change for some of these parents. And that is something that takes time. It's something that they might not have a lot of buy-in in the beginning to doing, but with case management services from the Division of Family Services and the case planning, then hopefully over a period of time, they're going to do that. We shouldn't be ruling out parents because in the first 3 months, they're not that invested in the process. They can change and things can still move forward in a way that's positive for the youth. So something to keep in mind is that, people change at different paces, and that this is generally a process for all of these people involved. So a lot of what I believe CASAs try to do in a lot of cases, and attorneys in cases, is to build a family tree with the parents so that we know who relatives are and we know who possible resources are. This is great. This is a great way to learn about the family. It's important because it's important that we have relatives that we know about in the event that reunification does not occur. So we want to know who is in this family who may be able to step up and have a relationship with the child, even if it's not a placement relationship. There might be a grandmother involved who still wants to just be a grandmother and visit and, provide gifts and see the kids on a holiday, that sort of thing. So we need to be mindful of that. When we want to find out who relatives are, it's best not to ask who relatives are who could take the kids, but just who the relatives are in general, because sometimes the parents might not want the child with a relative who's otherwise perfectly appropriate, or the parents might think that a relative is not interested in taking care of the child or unable to, and it turns out that they actually are interested and able. So we want to just find out just relatives in general, because we don't want to exclude those people who might otherwise be appropriate just because the parents are have a concern or think that they're not able to or willing to. But what we do want to keep in mind is that we want to be sensitive to the parents and what they're going through, especially in the beginning stages of the case. So in other words, now that we're getting back into court in person, if there's a preliminary protective hearing that we just get through and the child remains in custody and the parent's not happy about the child being in custody, it might not be the time to go out and talk to them about family and who they have who could take the child. A lot of times the parents are skeptical of that, and they think that when you start asking about family, especially early in the process, that you're already kind of ruling them out and moving on to a plan B. So if you say, after they have a preliminary protective hearing or an adjudicatory hearing and they're upset and it's, well, who else is there who could take the child? They might view that negatively in terms of we're ruling them out. Let's just move on. Find another source or resource for these kids. So be sensitive about timing. If parents are uncomfortable or unwilling at first, just be patient with them. They might come around later in the process. But it is important to have these family discussions with them. And it's important that they understand that we're not trying to say that they're not going to ever get the child home. We're just, it's a fact that when other family is involved in these cases early and involved considerably in these cases, then those family members who become involved early and actively are more likely to remain in that child's life, either as a permanent placement or as just a resource for them going forward. So we don't want to wait until the termination of parental rights hearing comes up or the permanency hearing and start asking about family then. We do want to do it early, but like I said, we have to be sensitive in the very beginning to the parents and how they might be feeling. And they're probably going to be overwhelmed with all of this in addition to that. So Stephanie was going to talk some about the parent-attorney process in general. Every child or every parent, excuse me, in these cases does not have an absolute right to counsel. It's not in the Delaware Constitution or law. However, you're going to probably encounter most cases where there's a parent attorney appointed to parents. Some cases where maybe a parent attorney is not appointed would include cases with older youth where DFS is very clear that they have no plans on moving towards termination of parental rights. Sometimes if parents or if children, the permanency plan is changed to another permanent plan living arrangement or APLA, sometimes the judge might remove parent attorneys at that point. But by and large, you're going to find that most of your cases have parent attorneys involved. So the way that it works in Delaware is that there are attorneys throughout the state who have a contract with the family court to be available for appointment to parents in these cases. In Kent County and Sussex County, there are 2 attorneys each. So 2 in Kent, 2 in Sussex, and in Newcastle County, I think that there are maybe 6, but I'm not positive about that number. And so by and large, the majority of the parents who have cases like this go to a contract attorney who does this regularly and is very familiar with the process. There are cases where there are conflicts with parent attorneys who have the contract, or there are maybe more than 2 parents. And in those cases, the additional parent or the parent who can't be represented by the contract attorney might go to an appointment from a private bar. So in other words, they're in Sussex and in Kent, they're just other attorneys. It could be a real estate attorney. It could be a criminal attorney who gets a contact from the family court and says that you are now appointed to represent this parent. So those cases can sometimes be challenging because the attorneys maybe aren't as familiar with the process and how things work. Prior to the pandemic, in order to qualify for the appointment of an attorney, the court had to find that the parent was indigent. They could not afford to hire their own attorney. Now, in light of the pandemic, the court is appointing attorneys to parents prior to even coming to the preliminary protective hearing. So appointment is sooner now than it used to be, which overall is a good thing. And there's a presumption that the court is making that that parent is in fact indigent. And that presumption can be disputed at the preliminary protective hearing if in fact that parent is not indigent. But so overall, the parent attorneys are appointed earlier, which is good because that gives them contact with the parents often prior to the preliminary protective hearing, which means they're more prepared for the preliminary protective hearing and things generally go smoother on that first court date. The parent attorneys are appointed from the beginning of the case prior to the PPH all the way through the appeal, if any. Their appointment can terminate if they are unable to maintain meaningful contact with their client and their client does not show in court. Most of the time it has to be 2 consecutive hearings. Then the court will sometimes remove that attorney and then the parent will again be attorneyless. Like I said before, the attorney can also be removed if maybe the permanency plan changes to something like APLA and there's not really a lot more involvement needed from the parent attorney. But what's new in the world of parent attorneys is that they're becoming an MDT or multidisciplinary team as well, just like there are multidisciplinary teams from DFS. We've got a multidisciplinary team going here with the triads. They are now becoming a multidisciplinary model as well. So that means is that there's the parent attorney who would be representing the parent in court and handling all the legal matters and probably a lot of the advisory things that happen outside of court as well. But parents are starting to get, and hopefully there will be more, social workers as well who work in conjunction with the parent attorney. They are not working for DFS. They are not working for our office. They are not working for any other independent agency associated with the case. They work for the parent attorney. And that social worker helps the parents function and complete their case plan. That's somebody who the parent can view as more on their team, I guess, if we're looking at this in a team's perspective, even though DFS is, working with the parent, trying to help them reunify. DFS's obligation is to the child. So ultimately, if there's a conflict between parent and child, that the DFS worker is going to go with the child and what's best for the child. This social worker, well, not discounting what's going on with the child, obviously, they're not going to put any children in danger, but they are working with the parent. They have a confidential relationship with the parent, so the social worker cannot be compelled to testify that the parent told her, X, Y, and Z that was negative. And from what I can tell thus far, it's only been in place for a year or two, but the social worker has been a huge help to the parent attorneys and to the parents in helping them maintain contact, helping the parents complete elements of their case plan, and just in general, making the cases have better outcomes. And what is also going to be happening very soon, but I don't believe has happened yet, is the peer parent advocate. So a peer parent advocate is going to work with the parent attorney and the social worker as well. And the peer parent advocate is a person who has been through this process themselves. So they are a person who has had a child in foster care and been through this DFS process. And so that person is intended to be able to provide firsthand guidance and information and encouragement to the parents going through this process. And other jurisdictions like New York have similar models, and it's been incredibly beneficial to parents in those places. So hopefully when this gets up and running, it will also be of great benefit to the parents and the system here as well. These people are all part of the parents' attorneys, the parents' team, and the CASA can and should reach out to these individuals with questions. For example, parent attorney, well, let me back up. Parent attorney, don't reach out to. Parent attorney is for me or whoever your attorney is to reach out to. But social worker and peer advocate, if they are assigned to a case, by all means, the CASA can reach out to them. The social worker could be helpful in helping you connect with a parent, even if you're having trouble. I know a lot of times CASA has trouble connecting with the parent, and the social workers are very good, at least thus far, to my knowledge, at hunting down the parents and finding them, and maybe they can even help you connect. They can answer questions that you might have about the parents' progress on their case plan. So by all means, reach out to the MDT professionals who are on the parents' team as well. All right, so in terms of communicating with the clients, or the parents, sorry, a lot of these parents do not have minutes on their phones, it seems. So a lot of parents might not be able to take your phone calls if you call them. However, a lot of the parents do have access to messaging, either through text messaging or different apps. Like I know that WhatsApp is one that sometimes people use, and there are a myriad of other apps that use data, but not voice minutes, so they can communicate more freely on Wi-Fi, even if they don't have any actual data on their phone plan. So be open to other means of communication with the parents if you're trying to communicate with them. That might even be something that's good for a conversation with them when you first meet them, and talk with them about how best to contact them going forward, whether it be through phone, email, or some of these other messaging apps. The dynamics between a parent and the CASA can change depending on where things stand with the case. For example, before the adjudicatory hearing, parent attorneys might not want CASAs or anybody talking to the parents, because these are kind of funny cases where the dynamic between the parties changes as the case progresses. So when you think of like a criminal case or a civil case where somebody's suing somebody else, at no point in time are any of those parties ever working towards the same goal. They're always at odds with one another. These cases are different because they start out where we're at odds, potentially, assuming the parents aren't in agreement with children staying in foster care. So we start out at the preliminary protective hearing and the adjudicatory hearing where we're at odds with the parents. And that's a potentially contentious period of time in the litigation. And parent attorneys will sometimes advise their clients, do not speak to the CASAs, do not speak to anybody without my express permission, until we actually have the trial, which is the adjudicatory hearing. So it is possible that before adjudication, you might not have a lot of success reaching parents, and that might not be because that's their choice, that might be their attorney's choice. So be mindful that they're not necessarily trying to exclude you. It could be on advice of counsel. And then after the adjudicatory hearing, what's unique about these cases is that the dynamic generally shifts and we're working towards reunification with the parents, where in theory, all of us are working towards the same goal. The parents are working on getting the children home. DFS is working on supporting them in that effort. And we're kind of taking a more hands-off third-party investigative approach, but we're also, supporting in theory the parents getting reunified as well. And then should things not happen where the parents are reunified with the child, then we come to the third stage where things become adversarial again, where DFS might be moving to change the permanency plan to something other than reunification, and we're possibly supporting that, possibly opposing that, and then moving on to termination of parental rights potentially. So things become adversarial again at the end. So again, you have to keep in mind that the dynamic with the parent might change kind of in conjunction with the way that the case is kind of flowing. If you have any kind of language barrier with the parents or the child for that matter, but I'm talking about parents, so be sure to communicate that with the attorney and the CASA coordinator. There are options out there, both formal and informal, to help you communicate. There's things like Google Translate, which I know can be very fairly reliable if you're actually communicating by text with somebody. So you can put things in Google Translate and it'll translate pretty much any language. But if you're having any issues with language in speaking with the parents, be sure to let the coordinator and your attorney know so that we can help you hopefully resolve some of those issues. All right, so and then as I mentioned, when we get towards permanency, the tenor of things changes again, and we're starting to move back towards an adversarial situation. So when we get to the permanency hearing, or shortly before, we're generally looking at what other permanency options are available for a child who hasn't returned home. There's options being reunification, termination of parental rights for purposes of adoption, a guardianship or a standard guardianship with a relative or non-relative, a permanent guardianship with a relative or foster parent potentially, and then of course another planned permanent living arrangement, which would be the plan that the child is essentially going to age out of foster care. So those are the options that we're looking at. And those options, DFS's position is dictated by the Permanency Planning Committee, or PPC. So what happens when permanency nears is that the Division of Family Services has to take the case to the Permanency Planning Committee, who makes the decision about what DFS's position is on what the permanency plan should be. You will be invited to attend any, or should be, I should say, invited to attend any Permanency Planning Committee meetings. At those meetings, the Division of Family Services presents the case. There are other players from other agencies, like supervising the foster home, for example, who might provide additional information. And then you will be able to also provide information and your position on the permanency plan at that time as well. Parents are not invited to the Permanency Planning Committee, and neither are their attorneys. If the Permanency Planning Committee changes the permanency plan from reunification to something else, it is not the CASA's role to tell the parents that. That should be DFS or their attorney who's advising them about a permanency planning change. If parents directly ask you about that and they don't know the answer, that becomes a little bit more complicated. You can refer them to their attorney or refer them to the DFS worker. Or you can, at your own risk, answer them. However, I normally advise against it because you want to make sure that they're hearing it from the right people who are able to fully answer any questions that they have. And quite frankly, we might not be in that position. So the parent's role changes often after Permanency Planning Committee meets and the permanency plan is changed. For example, if the permanency plan is changed from reunification to termination of parental rights, then the parents often have their visitation reduced from weekly or bi-weekly, however much they were getting before, to one time a month. The DFS worker who was assigned to assist the parents with completing their case plan is generally removed, and a permanency worker who works with the child is assigned instead. The parents because they don't have a treatment worker anymore who's assigned to work directly with them, it is possible the DFS is not gathering quite as much information about the parents and what's going on with them as they were prior to the permanency plan change. So that's something that the CASA can kind of step in to fill that void, hopefully, and continue to be in contact with the parent, continue to gather information about their progress or lack thereof, and hopefully, we'll be able to present that to the court in a meaningful way at subsequent hearings. In many instances, the parents will not give up just because the permanency plan has changed, and they will still continue to try to work on their case plan so that they can get the child or children home. And you can continue to support that in your role as CASA. You can continue to gather information, like I said, and you can, sometimes things change for the positive after a permanency hearing changes. It's not unheard of. So one of the things and biggest challenges I think we have in a lot of these cases are teen cases. So when we're talking about permanency, we should always be mindful of the age of the child, and because that directly affects the likelihood of having successful permanency outcomes for the child. So in other words, if there's a 16-year-old child and the parent, who's been living with the parents or one of the parents for their entire life and have a good relationship with that parent, even if that parent is, has a major substance abuse issue, major mental health issues, if it's a 16-year-old child, we're probably not going to want to terminate that child's parental rights and have the child just age out of foster care without a parent. We may, maybe we would support a plan of APLA if there wasn't anything else and the parent was really far gone. But I mean, really, we should continue to consider reunification, even in the worst of cases when there's teenagers who have substantial relationships with their parents, because where is that teenager going to go in 2 years, 3 years, when he or she ages out of care? She or he's going to go back to the parents, for the most part, most of the time, that's what happens. So the better, even if we're not going to be able to successfully reunify the parents with a child in a teenage case, we need to seriously consider all the supports we can give to that parent, so that if that child does age out and that child does return to the parent will be in the best position that he or she can be to hopefully, help the child out, or the child now adult out, when he or she returns to that home after aging out of foster care. So teen cases can be particularly challenging because there are parents who are really, seemingly hopeless in terms of being able to care for their children, especially when they're teenagers, and the parents seem to be, less adults than the children are even. But like I said, when these teenagers who are just going to end up going back to those parents after they turn 18, it's very important that we not just write off the parents entirely, that we continue to provide what supports we can to them, with the hopes that it will, improve things for their future and for the child's future, the youth's future, should he or she return home. So visitation tips. I know often the child attorney or the coordinator might ask you to observe a visitation or two with the parents. These can be really helpful for determining the dynamic between the parents and really getting a better sense of that parent's ability to meet the child's needs, because you get to actually observe a direct contact between the two of them over a period of time. Some things to be careful about with visitation is that we want to avoid being overly intrusive in the visits. The CASA should generally try to be a fly on the wall to the extent that you're in the same room as the parents during the visit. Depending on where the visits are happening, sometimes you might be able to even be in a different room and just observe a video of the visitation. I know in Dover at the DFS office, they have a visitation room with a video feed to another room. So that's something that you might be able to do depending on where the visits occur, where you can just be completely out of the room. Sometimes parents enjoy sharing some of their parenting time with CASAs and others, and sometimes they don't. So you have to be mindful of what the parents are like and what their desires are, because this is the only time generally that these parents are seeing their children during the week. So even if you're just observing a visit every once in a while, be mindful that that's the only time in general that the parents are getting with their child, and that we don't really want to disrupt that. We just kind of want to observe and report, so to speak. And that's all that I have for the presentation. I'm really sorry that Stephanie couldn't be here. I think she would have provided a lot of additional insight, being the current parent attorney right now and working not only with parents, but also working with the multidisciplinary team that parents attorneys have now with a social worker and peer parent advocate. But she is not, unfortunately, but I can do my best to answer any questions for you. I'm happy to be here, and if you think anything later, you can always let Lauren or I know, and I can try to answer questions then too.
Awesome, Mark. Thank you so much. I'll ask a question if you don't mind. In terms of how can a CASA encourage a parent to utilize the resources that are being offered to them, either through DFS or through the court in terms of an attorney, or anything being offered to them? What's kind of the best way for a CASA to go about encouraging them to utilize those resources?
Oh, wow. That's a really parent specific question, because
yeah, sorry.
Some parents are very open to utilizing the help that's available to them, and some parents are very much against it. I think that it's always probably best to focus it on the child, and that these, because if the parents are there in court and they're participating and working towards, at least in their mind, working towards getting the child home, then that should be a motivating factor for them. And hopefully, if you focus on how these services for the parents will ultimately benefit the child, and that's, the goal of these services, the goal is ultimately for the child to benefit from the services, even if they're services that the parent receives. So, I mean, maybe if you couch it in those terms, it can kind of change their perspective a little bit about the services. And then some parents are just not gonna, I hate to say it, but some of them are just, they don't recognize the need for the services, and they will fight you tooth and nail about it regardless. So you really have to, I think, pay attention to the parent. You can, like I said, if they have the MDT model set up on that particular case, you can talk to the social worker. Maybe that social worker will be able to provide some suggestions or insight into what they can get them to do. It's possible that the social worker might have a better relationship with the parent than the CASA does. Sometimes parents view CASAs adversarially, and maybe in those cases, then you can send your encouragement through the social worker, so to speak, and the social worker who maybe has a better relationship can assist with that. Yeah, it's hard. It's very case by case, I think.
Yeah, got it. Thank you. Sarah, you have a question. Feel free to unmute yourself and ask your question.
Hi there. I'll also hop on camera. I am working in a case right now that this is not this family's first interaction. Other older siblings have gone through the system. And I was not the CASA on that previous case, but what I'm noticing is it's hard to build rapport with the bio parents because they've kind of seen how this process works. Do you have any tips for establishing yourself as, obviously you're there for the child, but establishing yourself as an ally when they've already gone through, kind of seen the system work against them?
Right. If you're able to communicate with them, which I know sometimes when they're in that mindset, they don't really even want to communicate with you, but if you're able to communicate with them, you can probably stress that, you weren't involved in that past case. You don't know how things went down, how they were treated, that sort of thing. I hope that you obviously have some understanding of what happened in that case, but and that this is kind of like a clean slate, fresh start for them. Maybe if you're not able to communicate with them, or that doesn't work, and you have positive things to say about the parents, maybe you can talk to the attorney about asking you some questions about the parent at the next court hearing, so that maybe that parent can hear you say some positive things about them on the record. And then maybe that will help them see that, you're not so bad after all. I don't know.
That's a really good idea. I hadn't even considered that. So that's good.
Oh, good.
Yeah, definitely. That's great advice. That would be great.
Yeah,
Joyce, How are you doing?
I'm doing good. I had another meeting before this and it got out late. I'm sorry.
That's okay. Welcome.
But I know that it's recorded and I'll go back and listen to the beginning part of it. So I'm sorry I missed it. My question, I guess, is, and maybe you've answered this, how do you keep encouraging, what ideas would you do suggest for continuing to encourage the parent to work on their case plan when they kind of, I mean, we're at the TPR stage and basically they haven't progressed enough to do a whole lot and almost like they can see the writing on the wall.
Right.
How do you keep encouraging them to, continue to work on their plan, because it's not over till the judge makes his final decision?
I mean, I think that that's a good thing to point out to them, that just because the Division of Family Services wants this doesn't mean that that's the way it ends up happening. You can also encourage them that the things on their case plan, I'm guessing, are going to benefit them too if they follow through with it. Like I'm guessing it's probably, if they were to complete their case plan independently, even without the prospect of a child returning home, that would mean that they would get employment and housing and appropriate mental health treatment or substance abuse treatment. I mean, it's going to put them in a better position just in life in general, I think, to complete it. And it's hard because I think a lot of parents do give up hope. And, after they see the writing on the wall, so to speak, just kind of throw up their hands and go back into whatever addiction or place that they were before this all started. But I mean, I think you can always encourage them that, this isn't the end of the world. This is, you can make it a start of a new chapter in your life. If they're young, and they might have other kids in the future, you could talk about, get yourself in a better position. So if you have other kids in the future, that this is not going to happen again. I mean, it's hard though, because they do kind of lose the drive after the tables turn like that.
I know I'm so excited to see how the multidisciplinary team occurs and see how that works out between the parent attorney, the social worker specific to that parent, and the peer support, peer parent advocate. I think that's going to be so cool. Like, I'm excited to see how that works, how that's going to play out.
Yeah, and the peer parent advocate, I would hope, would be another voice to kind of keep them encouraged and try to motivate them, having been through the process before themselves. So hopefully that's going to get in place. I know they're in the process of hiring a peer parent advocate now. So
yeah, that'd be cool.
Yeah.
It's hard when you look at those case plans. I mean, parenting is hard no matter what. If you have a good support system, if you are financially, sound, if you have, reliable transportation. I mean, parenting's hard just with all those benefits, let alone if you don't have it, parenting is exponentially harder.
Yeah, it's also hard to recognize that, sometimes that it's an event that unravels everything, and then the parent is really struggling and trying to meet all the different goals at all the same time. And I mean, and even just them having the anxiety of having their child no longer with them, just put, trying to put yourself in their place, and even them just trying to meet one goal, let alone 6 different goals that they have to reach. It can be very, very disheartening too, because you're seeing them continually struggling, and you want also the best for them, but you're advocate for the child, really, And
it also goes the other way too, where sometimes parents will be very successful in their case plan and get to the point where they're close to having the child return to their care, or maybe even started a trial home placement. And it's important to keep encouraging them at that point, because sometimes they get to that point and they kind of start slacking off because they think that they're at the finish line and they're not. So I've seen plenty of cases fall apart right at the end because parents kind of worked really hard and then got complacent and things fell through. So it's important to remain that consistent voice of encouragement for them, for better or whether they're doing great or not.
Yeah.
mm-hmm.
Awesome. Joyce or Sarah, any more questions?
I have one quick question. I am having a hard time, as you talk about communicating with parents, I'm having a hard time communicating with mom and dad separately because they're always together. And sometimes I think we might get a more honest assessment of what's really going on if you can just have that conversation with mom or just have that conversation with dad. How important is that to like really try to like get them alone and have like a one-on-one conversation? And like, are there any strategies there? Because I'm kind of coming up short.
Yeah, that's tough. That really depends on the situation, I guess. Because if, how important is it if they're parents who are an intact couple and the plan is for the child to reunify with that family, then, they're going to be around, both parents are going to be around regardless when the child's there. But at the same time, there could be concerns, maybe if you have concerns about like domestic violence or that the other parent is, inappropriately influencing the one parent, maybe, then I think it's important to speak to them separately as well. So, can you even just say to her, or just say, I'm just assuming that let's just assume it's a mom that you're trying to speak with separate from dad. Just say to her, can I, speak to you separately? I really want to talk to you in private. You can talk to their attorneys, and maybe their attorneys can even help set up a time when you could maybe speak to that person individually. I can tell you though that that's a problem with the attorneys. If you're having a problem with it, I bet the attorney's having a problem with it too. Yeah. So
probably, yeah. Okay.
But yeah, even like, we're getting back into court in person, depending on where you are and what kind of hearings you're having. So if they attend, I don't think it's wrong to pull one of them aside after the hearing. And, if the other parent comes too, just say, do you mind if I just talk privately for a minute? And hopefully that's not an issue, but depending on the situation, maybe it is.
Yeah. See how that goes. Awesome. Mark, thank you so much for your time. We really appreciate it.
Yeah, I hope it was helpful. I'm sorry that Stephanie couldn't join us, but maybe another time.
Yeah, maybe we'll repeat this again in 2 years or something like that. But yeah, it's super helpful just to hear some information, remembering that we are on the parent side, especially in the beginning when we're working on reunification. When that is the plan, we need to do all we can as CASAs to support those parents until that's not the plan anymore. So keep on pushing. Awesome, everybody. Have a great day.
Okay, Lauren, this is